Hello, I'm Jennifer. Welcome to another episode of Case Brief, brought to you by the Missouri Sheriff's Association. Before we get started, I want to remind everyone that this information is for training purposes only and in no way is to be considered legal advice. Today, we focus on an Eighth Circuit court case related to handcuffing a person when they are simply being detained and are not under arrest. Our goal is to provide a clear understanding of how such cases unfold. Remember, this content is educational and not legal advice, so let's dive into the details. In 2016, Charles Waters refused to allow Menard's home supply store employees, pursuant to posted store policy, to search the trunk of his vehicle as he exited a Menard's lumber yard in Minnesota. Mr. Waters eventually called the police, who responded to the scene. Based on this encounter, Mr. Waters and his wife Anita filed a 19-count amended complaint in federal district court alleging violations of both federal and state law against the city, various police officers, and Menard, Inc. After appellants arrived in the lumberyard, a Menard's employee loaded the saw into their vehicle's trunk. Appellants then proceeded to the lumberyard exit, where a Menard's employee requested that they open their vehicle's trunk for inspection as per the signs. Mr. Waters refused, stating that he had no legal obligation to do so. When the gate employee refused to open the exit gate and called for a manager, Mr. Waters called the police. Let's examine the points at issue in this case. Did the officers have a lawful authority to detain Waters? The videos attached to the pleadings show that Mr. Waters refused to open his vehicle's trunk at the lumberyard exit despite signs at the entrance and exit informing visitors that vehicles would be inspected as they left the lumberyard. The requirement was clearly part of Menard's customary protocol as customers exited the lumberyard after picking up merchandise in their vehicles. Officers Smith and Kirchner arrived at Menard's in response to Mr. Waters' 911 call, and Mr. Waters refused to identify himself to the officers or to allow anyone to verify his purchase. At that point, Officer Smith and Officer Kirchner had a particularized and objective basis to detain Mr. Waters. His refusal to comply with Menard's clearly posted policy afforded them reasonable suspicion that he had something incriminating in his vehicle's trunk. Next, did Waters' detention become a de facto arrest? A Terry stop may become an arrest requiring probable cause if the stop lasts for an unreasonably long time, or if officers use unreasonable force. Officers must use the least intrusive means of detention and investigation reasonably necessary, and to conduct the stop, they are permitted to take any measures that are reasonably necessary to protect their personal safety and to maintain the status quo during the course of the stop. Finding that no unreasonable delay or unreasonable force occurred in the course of Mr. Walters' detention, the court held that the officers did not arrest Mr. Waters. Was there an unreasonable delay in Waters' detention? The Supreme Court has held that a 20-minute detention was reasonable when the police acted diligently and defendant contributed to the delay. Here, the video evidence shows that appellant's entire encounter with law enforcement lasted about 20 minutes, that the officers worked diligently to complete their investigation, and that the encounter only lasted as long as it did because Mr. Waters was argumentative and refused to cooperate with the police. Investigation by failing to obey legitimate requests to identify himself and step out of his vehicle. The court found no unreasonable delay. Please note that there is no magic to the time of 20 minutes. Longer detentions may be found lawful depending on the circumstances. The U.S. Supreme Court has not held that longer than 20 minutes will always be too long, nor has the court found that detentions less than 20 minutes are always lawful. Could the officers briefly handcuff Mr. Waters and detain him in the squad car? When the officers here arrived on scene, they spoke to the Menard's employees and Mr. Waters to determine the situation. They did not handcuff Mr. Waters or detain him in the squad car until he disobeyed multiple commands to provide identification and to step out of his vehicle. Mr. Waters exhibited suspicious behavior before the officers even arrived on the scene by failing to allow store employees to verify his purchase pursuant to a posted policy, and he continued to exhibit suspicious behavior by failing to identify himself or comply with the officer's instructions to step out of his vehicle. Mr. Waters eventually complied with orders to step out of his car. Officer Kirchner searched him for weapons and told him that the officers had reasonable suspicion that he had something in the trunk, stating, "You came into a shipment yard, which has a policy that you are not supposed to leave without showing the product that you have picked up, and you are not willing to do that." Officer Kirchner then handcuffed Mr. Waters, who is significantly taller than either of the female officers, and placed him in the back seat of a squad car. Mr. Waters is significantly larger than either Officer Smith or Officer Kirchner. The officers did not know Mr. Waters' background and witnessed his argumentative, evasive, and uncooperative behavior. They could reasonably conclude that Mr. Waters' unpredictable behavior would continue to escalate, and that handcuffing him and briefly placing him in the squad car was the least intrusive means of maintaining the status quo and protecting Mr. Waters themselves and bystanders while the officers investigated. The court noted that Mr. Waters' unpredictability, evasiveness, argumentative demeanor, refusal to obey legitimate officer commands, and the size difference between Mr. Waters and the officers, each viewed in isolation, likely would not justify the officer's use of restraints in this case. However, viewed as a whole, these factors could cause Officers Smith and Kirchner to reasonably believe they needed to handcuff Mr. Waters and place him in the squad car to preserve the status quo. Officers may reasonably handcuff a suspect and place him in a squad car in order to protect their safety and maintain the status quo. Officers Smith and Kirchner and Sergeant Madson, who arrived later to assist, are therefore entitled to qualified immunity. Was Waters' wife, as a passenger in the vehicle, unlawfully detained? It is well-settled law in this Eighth Circuit that both a passenger and a driver are seized during a Terry stop of a vehicle. If an officer acts lawfully in detaining the driver, he acts lawfully in concurrently detaining the passenger. As the court concluded, the officers acted pursuant to reasonable suspicion in detaining Mr. Waters. The vehicle's driver, they concluded that the officers acted pursuant to reasonable suspicion in detaining Mrs. Waters. The passenger. Did Officer Smith and Sergeant Madson violate Mr. Waters' Fourth Amendment rights by using excessive force against him? After receiving the trespass warning, but before leaving the lumberyard, Mr. Waters requested the officers' names and badge numbers. He approached Sergeant Madson to read the name and badge number off the sergeant's uniform. When Mr. Waters reached well within arm's length of Sergeant Madson, the sergeant physically turned Mr. Waters away from him and pushed him toward appellant's vehicle. The court found that Sergeant Madson used objectively reasonable force in redirecting Mr. Waters out of his personal space. Mr. Waters approached well within arm's length of Sergeant Madson, who was leaning on the squad car. Sergeant Madson then turned Mr. Waters away from him and gave him a light push in the direction of appellant's vehicle. The court found this to be a de minimis use of force, because a de minimis use of force cannot form the basis for a Fourth Amendment excessive force claim. It cannot be objectively unreasonable in this context. Sergeant Madson's use of force was reasonable under the circumstances, and the court affirmed the district court's dismissal of Mr. Waters' excessive force claim. Please note that the outcome could have been different if the amount of force used was found not to be de minimis. Did Officers Smith and Kirchner and Sergeant Madson search appellant's vehicle without lawful authority? Officer Kirchner approached Mrs. Waters, while Mr. Waters was handcuffed and in the patrol car, and asked, "Would you be willing to open the trunk for these gentlemen, meaning the Menards' employees, because that's the only thing that's holding us up here?" When Mrs. Waters explained that appellants had come into the lumberyard to pick up a saw, which a Menards employee placed in the trunk for them, Officer Kirchner stated, "It'd be doing us a huge favor if you could just bring that invoice and step out with these guys and pop the trunk for us. We'll chalk it up to Mr. Waters having a bad day." Mrs. Waters did as Officer Kirchner requested. A Menards employee and one of the officers looked into the trunk and verified the purchase. The officers then released Mr. Waters, issuing a trespass warning that prevented him from re-entering Menards for a year. The search of an automobile can be reasonable without a warrant if officers have probable cause or voluntary consent. Here, the officers contend that Mrs. Waters voluntarily consented to the search of appellant's vehicle, while appellants argue that Mrs. Waters was coerced into consenting. The district court concluded that appellants alleged sufficient facts to preclude dismissal of this claim on voluntary consent grounds, meaning the voluntariness of her consent was a question for a jury to decide. However, the district court also found that appellants failed to allege any actual compensable injury stemming from the officer's search of their vehicle's trunk, and thus failed to state a claim for damages. They did not allege any damages stemming specifically from the officer's search of their vehicle's trunk. The court therefore agreed with the district court that appellants failed to adequately plead a compensatory damages claim arising from the officer's search of their vehicle's trunk, and the Eighth Circuit Court affirmed the district court's dismissal of this claim. It is important to note that the court in this case did not decide whether the search of the vehicle trunk was lawful. It did not address whether there was sufficient probable cause to search the trunk without a warrant. That question remains unanswered. The court did not determine whether Mrs. Waters' consent was voluntary. The outcome on this point could be different if the appellants had incurred damages as a result of the search. For example, if searching the trunk revealed property attempting to be smuggled out of the yard without being paid for, and the appellants had been arrested. Just to be clear, the court in this case did not say officers can search vehicles given circumstances as in this case. In conclusion, Waters v. Madson serves as a critical case study on the importance of reasonable suspicion, lawful detention, and the use of force within the scope of the Fourth Amendment. The Eighth Circuit's ruling reinforces that law enforcement officers must clearly articulate that their actions are justified, objectively reasonable, and supported by clear legal standards. Thank you for joining us in this episode of Case Brief. We hope this analysis provided valuable insights into the types of specific factors needed to justify handcuffing a person while being detained as a result of an investigative stop. Stay tuned for more episodes brought to you by the Missouri Sheriff's Association. If you enjoyed this content, please like and subscribe. We look forward to bringing you more informative episodes in the future.